All right, everyone, the time is now 2 p.m. We're going to go ahead and get started. This is the state expedited accusations calendar. This calendar is for those individuals who've been recently arrested, but the cases have already been formally accused by the Solicitor General and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney today. When I ask you if you understand your rights, those are the rights that I am referring to. All participants, this particular proceeding is being broadcast over the internet. It is also being recorded. That means any member of the public can log on and watch this, just as if we were in person. Those who receive a signature bond will be reset further notice to a division judge. Those who receive a surety or a cash bond today will be reset to the state all-purpose calendar on November the 22nd of 2022. All right, are there any announcements regarding medical resets or releases from the jail?
No medical resets, Your Honor.
All right, who do we have first?
We're gonna go with position number 12, Mr. Amir Shazad. He has a private attorney.
I'm sorry, what position was this?
It's gonna be position number 12, Amir Shazad.
All right,
He has a private attorney.
okay. All right, good afternoon, Mr. Shazad. Your case is 22 CR 0076888. I will not sound the charge in this case, and the offense date is October the 10th of 2022. Do you understand your rights?
Go ahead, Chief.
Yeah, I'm sorry, ma'am.
You understand your rights here today at this proceeding, that you
Yes.
have a right to remain silent. Okay. All right, Mr. Howard.
First arrest.
All right, thank you. And whose case is this for the state? Is it yours, Ms. Salette?
Yes, Your Honor.
Okay, please proceed.
Yes, Your Honor. On October 17th, 2022, the victim in this case, Darlene Nobles, went into the Zone 2 precinct in Atlanta and stated that on October 10th, 2022, the defendant grabbed her breast and buttocks and tried to pull her into the restroom, placed his hands between her legs and slid it down into her pants. There was a witness that was a witness to this, Ms. Fala, F-A-L-A, and she stated that she was at work that day on October 10th when that incident happened and did witness it, and also heard the victim telling the defendant to stop. Just a little bit of more background about this case. This incident did happen at 639 Morosgo, M-O-R-O-S-G-O Drive in Atlanta at an emissions Circle K check. The defendant is the owner of that Circle K, and the victim is an employee, and the witness to the incident is an employee as well. The victim has stated to us that third parties have been contacting her about this incident and saying that the defendant is apologetic, wanting her to settle this case civilly. And the victim does have text messages from the defendant apologizing for this incident. To the fact that the defendant does own the Circle K and there is an employer relationship with this case, the state would argue that the defendant is in the position to intimidate witnesses. And due to the nature of the charges, the state would be recommending a $10,000 surety bond, no alcohol, drugs, or weapons while out on bond, and no contact with the victim. We've also been told that the victim does now work at a different Circle K location about 80 miles away. So the no contact shouldn't be an issue at this time.
All right, thank you so much. Counselor, if you'd like to enter your appearance at this time and give me your recommendation for bond.
Can you hear me, Judge?
I can. Good afternoon.
Good afternoon. Kamisha Benz on behalf of Mr. Shazad. Your Honor, the defense is we're asking for an OR bond in this case. And if Your Honor is not inclined to grant an OR bond, then a bond not to exceed the amount of $3,000. Would you mind if I provide just a little bit background? It's somewhat different from what Ms. Courtney's provided.
Very briefly, yes, ma'am, please proceed.
Briefly, Your Honor, this is a situation where the alleged victim in this case does work for the management company of my client. My client has management contracts with several gas stations throughout the metro Atlanta area. She is still employed for Mr. Shahzad, and in terms of no contact, the victim has been contacting my client multiple times through text messages, through calls. And so we don't believe that he poses any threat to her at all. She also, Your Honor, frankly, we believe that this is a case in which the alleged victim is attempting to extort the defendant in this case. We've got several text messages asking for money to make the case go away, et cetera. And so, my client is 54 years old. He's never been in trouble before, owns his own company. He's not likely to flee. He actually turned himself into the jail. We make arrangements with the investigator to let him know that he was going to turn himself in. And so we don't believe that he poses, that he meets or doesn't meet any of the bond factors. And so we'd ask that you grant an OR bond or a bond not to exceed in the amount of $3,000 surety bond.
Is the alleged victim on the line and wishes to be heard? I'm sorry, what is the alleged victim's last name?
One moment, Your Honor. That name is Nobles, Nobles.
All right, Ms. Nobles, if you're on the line and wish to make a statement, you're free to do so, but you're not required to. Do you wish to make a statement at this time? If you do, I would have to swear you in first. You'd have to unmute yourself. So you wish to make a statement? I'm unable to hear Ms. Nobles. Is anyone else?
No.
Yeah, I cannot hear. Ms. Nobles, we can't hear you. You've joined the audio part of the conference, I believe, because I saw that your mic went off, but we can't hear you. Okay, we still can't hear Ms. Nobles. All right, Ms. Nobles, we are gonna have to move forward. We're unable to hear you at this time, but I believe that I've heard from the state and defense regarding this case. Ms. Nobles, if you want to make one more attempt to make a statement, maybe leave the Zoom conference and come right back. All right. At this time, the defendant will receive a $3,500 surety bond. He is not to have any contact whatsoever with the alleged victim in this case. And I believe that will address, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further from either party?
Your Honor, we would request that include any mention of her on social media or any third-party contact.
All right. All right.
I do have one more. I'm sorry, Judge. I do have one more thing. There's going to have to be somewhat of some third-party contact because of the way that she has to submit her not leave sheets, but she has to submit time sheets. He does have another manager in place to be able to deal with the victim in terms of making sure that she gets payment every Tuesday for her hours, but she does have to, there may be some sort of third-party contact so that the manager can reach out to her.
He's not to contact her for other than any strict payment or employment purposes. Otherwise, he's to have no discussion and no direct contact with her whatsoever.
Thank you.
So it would have to be through that manager or whoever's in place to handle personnel issues at their business. All right?
All right, and what was that date for?
He will be reset to the November 22nd SAP calendar, but that's assuming he is not able to make bond. If he makes bond, he will be reset further notice.
Okay, thank you, Judge. May I be excused?
Yes, you may. Take care. Have a great afternoon and best of luck to you, sir. Who do we have next?
Your Honor, next we have position number 3, Mr. Vincent Grover, position number 3.
Okay, good afternoon, Mr. Grover. Your case number is 22 CR 007649G. You're charged with 1 count of obstruction and 1 count of driving on the wrong side of the road with the offense date of October the 30th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
Second arrest, 2015 misdemeanor possession of marijuana.
All right, thank you. And whose case is this for the state? Is it yours, Ms. Campbell? If it is, please proceed.
Yes, Your Honor. Naomi Campbell on behalf of the state. And the facts as alleged for this particular incident are that on October 30th of this year at 3:29 in the morning, this defendant was at the intersection of Marietta Street and Northside Drive. Essentially, he obstructed an officer in his lawful duties by speeding up and driving around the officer while the officer was attempting to conduct a traffic investigation. And so, as pretrial mentioned, this is his second criminal cycle, but the state would also add that he has a prior 2018 conviction for a traffic charge, improper use of a U-turn. There's also a 2016 improper lane change, a 2015 speeding. And so with all of that taken into consideration, the state's recommendation to the court is a $2,500 signature bond through pretrial services. And the breakdown of that bond recommendation is $2,000 on the obstruction charge and $500 on the driving on the wrong side of the road charge.
All right, thank you. Ms. Moses-Cross, your response.
Yes, yes, Your Honor. Thank you. My client, Your Honor, is 25 years old. He does have a good address of 696 Erin Avenue, Southwest in Atlanta. He would not qualify for the service of the public defender after today. He does have good employment. He is a Coca-Cola financial analyst, and therefore his income is over our limit for representation. So he has been made aware of that. Your Honor, after speaking to my client, he has informed me that there was a traffic accident and that another officer waved him off to proceed on around, and that's when he was stopped by whoever this present officer is, and that's the basis of this stop, Your Honor. He is not obstructing of any other offenses, and therefore he doesn't have any other lengthy criminal history. I would also agree that he should qualify for a signature bond. I would ask for the signature bond to be granted in lieu of the fact that he does not have a legitimate criminal history.
All right, at this time, defendant will receive a $2,500 signature bond through the jail, 2,000 count 1, 500 count 2. He's to have no alcohol, drugs, or weapons. Is there anything further from either party?
No, Your Honor.
No,
Thank
Your
you.
Honor.
All right, best of luck to you, sir. Who do we have next?
I'm sorry, Your Honor, what was that bond amount?
2,500, 2,000, and 500.
That's security bond?
SOB through the jail.
All right, thank you. Next we have position 14 and 15, Mr. Charles Watts.
All right, Mr. Watts, you have two cases, so I'll read them and we'll address them at the same time. Your cases are 22 CR 00790F, and what you're charged with one count of battery family violence with the offense date of October the 12th of 2020. And the second case is 22 CR 007691F, and what you're charged with criminal trespass and damage to property with the offense date of September the 10th of 2020. You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
22 total. Last arrest was 2018. Driving without a valid license conviction. 2017 parole violation. 2016 FTA for battery DV. It was NOD. Came off a 2016 battery arrest. 2016 parole violation. 2016 FTA for battery. Probation violation 2014. 2014 theft by taking conviction. 2014 probation. 2014 hindering person from making emergency call, simple battery DV conviction. 2014 failure to appear for battery DV. 2013 probation. 2013 identity theft fraud, 1, 2, 3 counts, 1 count trespass conviction. 2012 battery DV, it was dismissed.
Okay, I think that's good. Thank you, Mr. Howard. All right, Ms. Salat, please continue, or please proceed.
Your Honor, I'll start with position 14.
All right,
On October 12, 2020, Officer Hadley was dispatched to a fight call at 445 Cleveland Avenue, apartment J99. Upon arrival, he met with a Miss Lakeisha Maddox, and that's Lekesha Maddox, Maddox. And that an incident occurred with her child's father, the defendant in this case. They do share two children together. She further explained that she had come home from work earlier and the defendant began arguing with her for no reason. He asked him to leave her alone and he continued to argue with her. She ignored him. He escalated the argument from being verbal to physical. And during that physical altercation, he began choking her. The victim was able to break free from his grasp and call the police. And while Officer Hadley was gathering further information about the incident, the defendant was texting the victim, threatening text messages saying that he would beat her up in the future, that he was going to damage property of hers as well. The state's recommendation on this case is a $5,000 surety bond, no alcohol, drugs, or weapons, no contact with the victim, stay away from the incident location, only third-party contact for the children. Based on the defendant's history, he does have 2016 battery family violence arrest, 2013 battery family violence arrest, and a 2014 simple battery family violence conviction. So he's shown a pattern of violence, specifically family violence. And so the state would argue that he poses a risk of reoffending in the future. I also noted 3 failure to appear arrests between 2014 and 2016. So the state would argue that he also poses a risk of not appearing for court in the future as well. Would you like me to proceed with the other case or did you want to rule on this case?
Yes, please. No, yes, please.
Yes, Your Honor. Position 15 on September 10th, 2020. So this happened about a month before the other incident. My apologies. At the same incident location at 445 Cleveland Avenue, apartment J99, the defendant damaged 3 doors at Ms. Maddox's apartment by kicking them. And the front door was so severely damaged that the locks on the door became too hard to lock and unlock. On this case, the state is requesting $1,500 surety bond, same conditions as before, no alcohol, drug, or weapons, no contact with the victim, and stay away from the incident location.
All right, before we proceed to Ms. Kim, is Ms. Maddox on the line? I'm sounding for Ms. Maddox at this time. Is Ms. Maddox present? All right, hearing none. Ms. Kim, please proceed.
Yes, Mr. Watts is 33 years old, and he was born and raised here in Georgia. He has 5 minor children, and he has been paying child support every week. It goes directly to children. He has all his family members here in Georgia, and he used to have a very good, solid job. However, he's afraid that he's not going to be able to continue that job because he was shot last Thursday. He was in the Grady Hospital, trying to get, he got the rod on his leg, both legs. He got 2 shots. So his both legs cannot be moving right now. So that's why he's in wheelchair. He has to take pain medicine. He really needs to do physical therapy for him to be able to walk again. And this incident happened about 2 years ago, more than 2 years ago, Your Honor, September 10, 2020, October 12, 2020. So we would like to request for a signature bond on these 2 charges so he can go get physical therapy and be able to be healed properly. And I think he's going to have a really, really hard time financially since he's afraid that he's going to be unemployed from going forward. So we would like to request for a signature on bond. Thanks.
All right, thank you, Ms. Kim. At this time, the defendant is going to receive a total $2,000 surety bond, 1500 for the case ending in 690F. Oh, I apologize. I did sound for Ms. Maddox. I'm going to make sure she's not here again to be heard. All right. Yes.
Sorry, I just wanted to add that I just wanted for the record that our office has had contact with Ms. Maddox, I think in the last hour, and she does not have a problem with no contact. So
Okay, that's what the court is going to issue if she wasn't here to make a statement. So
Thank you.
he has to have no contact with the alleged victim, last name Maddox. He'll have a $1,500 surety bond for position 14, and he must stay away from the incident location on Cleveland Avenue. He can return one time with a member of law enforcement to get any items that might still be there, and have no alcohol, drugs, or weapons. On the case ending in 7691F or position 15, that will be a $500 surety bond. Same conditions, no contact with Ms. Maddox, stay away from the incident location, can return one time with a member of law enforcement to get any items, and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Next, Your Honor, we have position number 4, Ms. Hernandez Ariola.
All right. Good afternoon. Your case number is 22 CR 007894Y, and once you're charged with 2 counts of criminal trespass, you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
She got pre-trial yesterday. I guess her warrant came back before she got released.
Your Honor, Ms. Hernandez was on the calendar yesterday. She informed me that apparently whoever missed that she had a second criminal trespass. I don't know if you were the judge for yesterday, but she was given a $3,000 signature bond through pretrial. Stay away from the incident location, no contact with the named victims in that case, or in this case, this is a part of the same, I believe, offense.
Okay. I was not here yesterday, so this was part of the same case. Ms.
Yes.
Howard, this is her first arrest. This whole case is her first arrest.
No.
I don't know
I think
about
they-
first arrest, but I was informed by the jail that this was missed from yesterday, so they brought her back.
And Your Honor, if I can give a little more clarification, she did have 2 open warrants for an incident a day of November the 7th. And she had 2 charges for criminal trespass, but I guess someone overlooked that there was 2 warrants, but it should have just been 1 case. So we did proceed with the bond hearing on one of the counts of criminal trespass yesterday. However, we have not addressed her second count of criminal trespass. And so if Your Honor is inclined, the state would recommend proceeding with that bond argument today.
So for count 1 of this case, she has a $3,000 signature bond. And we need to proceed with count 2. Is that correct?
That's correct, Your Honor.
Okay, so the 3,000 signature will stand that's given yesterday, and we'll proceed with count 2. And Mr. Howard, can I have the history now, please?
.2010 hit and run, driving without a valid license. The hit and run was dismissed. The valid license was reduced to expired license conviction. Oh, yeah, she the one with the all she got is driving history. She don't have any
Okay.
violence or anything.
Okay, thank you. Ms. Campbell, please proceed.
Yes, Your Honor. The facts as alleged for this particular defendant is that on the date of November the 7th of this year, this defendant was actually made an unlawful entry into the property of her ex-husband. The listed name of that victim is Armando Mija Marquez. And so as it pertains to this specific charge, she entered the front door of the property without the owner's consent. The door was unlocked, and she entered the property for the purposes of committing an assault upon a third party located inside of the residence. And so as pretrial mentioned, she does only have prior convictions for driving related offenses. So the state's recommendation for this criminal trespass count is a $3,000 signature bond through pretrial services which is what she has on the other count, as well as the same conditions, which are no contact with Armando Mija Marquez, no contact with the third party, Wendy Herrera Moreno, as well as a stay away from the incident location, which is her ex-husband's house. And that is located at 560 Creekwood Crossing, and that is in Roswell, Georgia. Nothing further from the state.
All right, before I go to Ms. Moses' counts, I'm gonna sound for either victim in this case. Mr. Mija Marquez or Ms. Moreno, or either of those parties on the line and wish to be heard? All right, Ms. Moses, counsel, do you have any objection to the state's recommendation? I'm inclined to grant it at this point.
I have no objection, Your Honor. I would like the court to know that she does have a separate address, and so stay away is fine.
All right, at this time, I will accept the state's recommendation. On count 2, she will receive a $3,000 signature bond through pretrial services. She's to have no contact with Mr. Mija Marquez or Ms. Moreno, and must stay away from the address on Creekwood Crossing. Have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor.
All right, best of luck to you. Who do we have next?
Question. On charge 1, is she gonna get a $3,000 SOB as well?
Yes, it's the whatever was given yesterday, Ms. Bridgewater will stand. I believe that's what it was. So we can say I'm adopting yesterday's recommendation of the $3,000 SOB.
Yesterday, so was it?
Yeah, neither was I. 3,000 SOB through pretrial on that charge as well, for a total of a 6,000 SOB.
Thank you.
Next, we have position number 5, Ms. Hobbs, position number 5.
All right, good afternoon. Your case number is 22 CR 007696Y, in which you're charged with 4 counts of reckless conduct and 1 count of contributing to the delinquency or independency of a minor. I'm sorry, dependency of a minor. My print is very small. Each with the offense dates of November the 8th of 2022. You understand your rights?
Yes.
All right, Mr. Howard.
It's a second arrest. 2010 careless driving out of Mississippi. That's all I got.
All right. Ms. Duncan, please
Good
proceed.
afternoon, Your Honor. This incident took place yesterday in the area of Georgia 140 and Scott Road. It was around 7:10 p.m. So it was likely dark at that time. In this incident, Your Honor, there is a preset bond for the first 2 counts. However, the state has added an additional set of counts, given the facts in this case, which are that officers conducted a traffic stop on a gray Dodge. And when they made the stop on that vehicle, the driver of the vehicle was the accused son, who is 14 years old and unlicensed. That's minor JH. But the defendant was present in the vehicle. However, she was in the passenger side of the vehicle. And officers noted that there were 3 other minors in the vehicle, JH, JM, and JJ, ages 10, 3, and 5, who were not properly restrained at the time. When officers spoke to the passenger, which was the defendant in the vehicle, she stated that they detected an odor of alcoholic beverage on her breath, and she stated to officers and admitted to consuming alcoholic beverage. And due to her inability to drive at that time, she permitted her 14-year-old child to drive. Officers notated that the vehicle's lights were not on in the dark conditions, and that child driver had failed to maintain lane several times, which was the reason for the stop. Upon further talking to the defendant, she did try to state to officers or recant her previous statements and say that she was just trying to teach that child how to drive. Officers were concerned, and at that point, the defendant was taken into custody. We do have some concern about the risk of reoffense here, given that this defendant does have a previous careless driving arrest out of Mississippi. We do have some concern about the safety of the particular victims in this case, as they are children and they were put in this careless and dangerous situation. Officers did notate that the traffic conditions were very heavy at that time as well. We're gonna request that the preset bonds on the first two counts remain as set. And in addition to those on the additional reckless conducts, we're gonna ask for 1,500 per, making it a total of a $7,000 total surety bond. So for the first reckless conduct, 1,500. For the contributing to the unruliness or delinquency of a minor, it's a $1,000 preset bond. And then for the other three counts of reckless conduct, we're asking for 1,500 per. We're gonna ask that there be no alcohol, drugs, and weapons, a parenting class, and no further contact with any of the victims in this case. Nothing further from the state at this time.
All right, when you say the victims, you mean the children at
Yes,
the time, Ms. Duncan. All right, Ms. Moses Counts, please proceed.
Yes, Your Honor. My client is 35 years old. She does have a good address of 405 Ashley Court in Alpharetta. She does have the 4 minor children, ages 14, 10, 5, and 3. She is employed. She works at Coca-Cola. And based on her income, she will qualify for the services of the public defender after today. I have informed her of that. Your Honor, there's no way that Ms. Hobbs will be able to post a $7,000 surety bond, and she's the sole provider for these children. It is in dire need that she be released to continue to provide financially for these children. Based on the complete lack of any real history, I would ask for your consideration of a signature bond for all offenses, especially these newly added offenses that I was not made aware of prior to this moment. And so based on that, I would ask for your consideration of a signature bond.
All right, at this time, Ms. Moses Counts or Ms. Duncan, is the state aware where the children are at this time, or who's providing care for them?
the
If I
state,
were to grant this stay away, where will the children be housed?
the state is not aware at this time, but given the extreme risk to their safety, given the facts, that's our recommendation.
Your Honor, I would object to a stay away. The children, she's the sole provider for these children. There is no one else. So I don't know why the state would request that if they had no plan B for these children. So
Well, we do have to consider the serious nature of it, but I am concerned and then no one is aware of where the children are now, or who has them?
Ms. Hobbs, are you able, can they take her off mute? Where are your
Just to answer
children?
the-
I don't
just
want
that
you to,
one-
I'm
Yeah,
sorry.
just
Your-
one just answer your attorney's question. Please don't say anything else. Go ahead, Ms. Moses.
Right, Ms. Hobbs, you have the right to remain silent, and I don't want you to say anything factually about your case. I just simply want you to state if you know where your children are presently.
Yes,
And where are they?
with my cousin,
Who?
with my cousin.
Your cousin, okay.
All right, is there anything further from the state of the defense?
Your Honor, I would just say if you are considering this a stay away, again, I would object to that and ask, since she's gonna have to stay in connection with pretrial, that maybe they log or check in on her through that for the care of the children. But again, she is the sole provider for them. And so I would ask that you not permit a stay away from the children.
And the state will just reiterate the seriousness of the offenses alleged, nothing further.
All right, I am not gonna give her a signature bond at this time, Ms. Moses Counts. Ms. Hobbs is gonna receive a $5,000 surety bond. That will be $1,000 for each charge. She is to have no alcohol, drugs, or weapons, and she is to have no contact at this time with the alleged victims in this case. Again, this case will be reset to the November 2nd SAP calendar. At that point, contact can be revisited. All right,
Thank
is there
you.
anything further?
Nothing further.
All right, best of luck to you, ma'am. Who do we have next?
Next, Your Honor, we have position number 11, Ms. Robinson.
All right, good afternoon, Ms. Robinson. Your case is 22 CR 007687C, in which you're charged with battery family violence with the offense date of November the 8th. You understand your rights?
Yes, ma'am.
All right, as seeing as how this is her first arrest, we'll go straight to Ms. Solette.
Yes, Your Honor. On November 8th, 2022, Officer Woods responded to the location of 1058 Ridge Avenue. Upon arrival, Officer Woods spoke with a Miss Kimyetta Williams, that's Kim YETTA Williams, who stated that she and the defendant are in a relationship and were living together, and they got into a verbal altercation over rent money not being available at the time. Ms. Williams stated that she confronted the defendant about the missing rent money, and that's when the defendant swung on her or punched her and began a physical altercation. Officer Woods also spoke with another witness that was on the scene at the time, a Miss Fraser, Fraser, who stated that she witnessed the defendant pushing the victim. Officer Woods observed injuries to both defendant and the victim's hands, and the defendant was taken into custody at that time based off that eyewitness testimony. The state's recommendation at this time is going to be from the battery family violence charges, a $4,000 surety bond, no alcohol, drugs, or weapon while out on bond, no contact with the victim, stay away from the incident location. And that's due to the nature of the charges. The state would argue that the defendant poses a risk of reoffending to this being a family violence incident. Nothing further from the state at this time.
All right, I'm gonna
Good
sound.
afternoon, Your Honor.
Before you begin, Ms. McLeod, I'm sounding for Ms. Williams. Is Ms. Williams present on this Zoom conference and wishes to be heard? All right, hearing none. Good afternoon, Ms. McLeod, please proceed.
My client is 22 years old, Your Honor. She is gainfully employed. She tells me that she was the one who called the police because she had been attacked by the alleged victim. She was very surprised that the police officer chose to arrest her. This is her first arrest, Your Honor. She has no record, so I would ask the court to give her a signature bond so that she can get out of jail, get back to work, and get on with her life. She does have somewhere else that she can live, and she does not especially want contact with the alleged victim either. She does need a one-time police escort to go back there because she has important documents and all of her personal belongings at this location, Your Honor. So we do need that one-time police escort for her to get her things. But she's okay with no further contact.
All right, at this time, Ms. Robinson will receive a $6,000 signature bond through pretrial services. She's to take the one-day anger awareness course, have no contact with the alleged victim, last name Williams, and stay away from the incident location. She can return one time with a member of law enforcement to get any items, and she's to have no weapons, drugs, or alcohol. Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you. Who do we have next?
Next, we have position number 1, Mr. Ronnie Brown.
Good afternoon, Mr. Brown. Your case number is 22 CR 007693E, in which you're charged with theft by shoplifting with the offense date of October the 24th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
A 14 adult arrest. He's on probation in Fulton for shoplifting, criminal trespass. It's 22 CR 006-454E as in Edward. He had an armed robbery with a firearm conviction out of Louisiana. I think we had him recently. 2009 probation violation, 2009 possession of a Schedule II drug, 2009 reckless operation.
I think that's good. That's the last 10 years. Thank you. Ms. Campbell?
Yes, Your Honor. The facts as alleged for this defendant are that on the date of October 24th, 2022, this defendant was at the location of 3 Joseph E. Lowry Boulevard in Atlanta. That's a Texaco gas station. While he was there, he did steal 2 12-packs of beer out of that Texaco, and he walked past all points of sale without paying for those items. This particular incident was captured on surveillance video inside of that gas station, and the defendant, the officer was already familiar with the defendant in light of the fact that the defendant had committed previous theft by shopliftings within the same vicinity of this Texaco. More specifically, just to go a little bit more into this defendant's history, he currently has 6 open cases in Fulton County State Court. At the time he was picked up on this warrant, he also had 5 outstanding warrants or charges for theft by shoplifting, all within the past 3 months here in Fulton County. According to the police report, they all took place in either Zone 1 or Zone 5 of Atlanta. As your honor knows, because of what pretrial said, there's a conviction from September. Well, the incident date was September, but the conviction was October the 6th. And that was with you, your honor, Judge Melanie Williams. You sentenced him to 12 months to serve 14 days, the balance to be probated. You also instructed that he complete anti-theft classes as a part of his probation. You instructed him to stay away from a Walmart in that case. Prior to your honor convicting him for that theft by shoplifting back on October 6th of this year, Judge Law also found this defendant guilty for criminal trespass. He was sentenced to 2 days on that particular case. He was instructed to stay away from a MARTA station here in the city of Atlanta. And then we have the prior arrest before this one from October 26th, and that one involves 5 different incident dates where the defendant is alleged to have been committing the same exact crime of theft by shoplifting. We have incident date of October 9th, October 14th, October 20th, October 19th, as well as October 16th. And these all took place at different incident locations. He's actually out on bond on that case. And he's on the SAP calendar tomorrow for those 5 different theft by shoplifting charges. He has a $2,000 500 total surety bond on that open case. And he also has another open case, 22CR007370E, before Fulton County State Court. And that is also for theft by shoplifting, as well as obstruction, as well as possession of drug-related objects. He has a $2,000 good bond on that case. So what we have before the court, your honor, is somebody who is a severe risk of reoffending, in light of the fact that he has 2 convictions here in this court within the past 2 to 3 months. He's got 2 open cases, now a 3rd open case pending before this court. He's out on bond on 2 of those open cases. And so the state does believe that he poses this severe risk of reoffending. He's been doing a lot of stealing out in the community. It seems like nothing is deterring him. The bond conditions are not deterring him. The time he spent in jail is not deterring him. The anti-theft class is not deterring him. His 12-month probation is not deterring him. So the state is seriously concerned about this defendant and his placement within the community. The state is also concerned about him being a risk of flight, considering the fact that, as pretrial mentioned, he does have that history out of Louisiana. More specifically, he has a 2022 conviction from January of this year for battery, domestic abuse. He also has a violation of probation from that case. He also has a 2021 conviction for aggravated assault, domestic abuse out of Louisiana. So the state is concerned that he might go back to Louisiana, because just as recently as the beginning of this year, he was convicted of a felony there. And on the officer's citation sheet, it shows that he still got that New Orleans driver's license, and he still has a New Orleans address being listed as his resident when he was picked up on this charge. So currently, this defendant does have a $1,000 surety bond on this case alone. The state's recommendation at this time is that this bond amount be increased to a $5,000 surety bond. The state is also recommending that this defendant be instructed to stay away from the Texaco located at 3 Joseph E. Lowry Boulevard, and nothing further from the state.
All right, thank you. Ms. Kim, please proceed. Or is this your client, Ms. Kim?
No, Your Honor, I believe this is another Miss Jasmine Moses count.
Miss
I
Moses
was
count.
texting her. Oh,
Miss
here she is.
Moses count.
I'm sorry, what position, who is this?
First one, isn't it Brown?
Mr.
Are we
Brown.
talking about?
This is Ronnie Brown?
Yes.
Yes,
Oh, okay, I'm sorry.
that's okay.
Your Honor, my client is 30 years old. He does have he's homeless. He provided me the address for the Salvation Army. So there's that. He doesn't have a phone number or email address for us to maintain contact with him. But he did inform me that prior to this arrest, he did have a new phone, but he does have a phone that I guess was taken in his property, but he doesn't know the phone number basically. And so he would not have the means to post any bond, quite frankly. I would just stress to the court again his means and ask that you would keep that in your consideration for bond.
All right, at this time, the defendant's bond will remain as set at the $1,000 surety bond. He is to absolutely stay away from the location on Joseph E. Lowry. And he is to have no alcohol, drugs, or weapons as a condition. Is there anything further? All right, best of luck to you, sir. Who do we have next?
Next, we have position number 6, Mr. Tyrone Hughes.
All right, good afternoon, Mr. Hughes. Your case number is 22 CR 00701F, 7701F, in which you're charged with simple battery family violence with the offense date of November the 8th. You understand your rights?
Yes.
All right, Mr. Howard.
23 total. Last arrest was 2021, sale of cocaine. He has a open case out of Superior Court, 21 SC 178165. On probation, criminal damage to property, second degree, possession of tools, terroristic threats, possession of a knife or a firearm during the commission, possession of a firearm by convicted felon, theft by taking, misdemeanor possession of marijuana. 2016, they gave him a 10-year sentence for that.
All right, thank you. Ms. Campbell, please proceed.
Yes, Your Honor. The facts as alleged for this defendant are that on the date of November 8th, 2022, between the hours of 12:30 in the morning and 2 in the morning, officers were on patrol in the area of 3843 Jonesboro Road, which is an Exxon gas station. The officers heard what they believed to be fighting sounds coming from the gaming machine area. And as the officer walked around the corner, he did observe the defendant that he later identified as Tyrone Hughes push the victim in this matter. Her name is Ayanna Williams. He pushed her into a gaming machine. And so the officer, pursuant to further investigation, reviewed the surveillance video to see what happened before he walked on into this altercation or this attack. And when he reviewed the surveillance video, he saw that the defendant also punched the victim, Miss Ayanna Williams, and he punched her with such force that she actually slammed into the wall and her hat flew off her head. The defendant did later admit to the officer that this was not his normal behavior and that they had been going through issues. The defendant and the victim do live together. And so that's why it's been charged as a simple battery family violence. Pretrial gave, Your Honor, most of the history. What I would also like to highlight is the fact that this defendant currently, when he got picked up on this case, he also had an open FTA warrant for a Superior Court case involving the possession and the sale. Sorry.
We lost you, Ms. Campbell. There you are.
I'm sorry. He also had an open warrant at a Superior Court for possession of controlled dangerous subject, basically for the sale of drugs. And so he has a no bond on that case. And the state's recommendation for this defendant today is that he be given a $5,000 surety bond. And that's because of the lengthy criminal history. And that leads the state to believe that he's a risk of reoffending. And he's also got the prior FTAs, the most recent being from, it looks like September of this year, hence him being picked up on an FTA warrant. The state does believe that he's a risk of not appearing for court, and that he's also a danger to the victim because he essentially physically attacked her in a public place, and the police were just, arguably a few feet away. So the state is concerned about the victim's safety, and the state is also concerned about him not appearing for court. So the $5,000 surety bond is the state's recommendation, as well as no contact with the victim, Ayanna Williams, and that's AYANA, as well as a one-day anger awareness course and a stay away from the incident location of 3843 Jonesboro Road. Nothing
Right.
further.
Is Ms. Williams currently present on the Zoom conference and wishes to be heard? I'm sounding for Ayanna Williams. All right, hearing none. Ms. McLeod, please proceed.
Yes, Your Honor. My client is 36 years old. He tells me that he's currently unemployed. He does admit that he and the alleged victim were living together, but he has somewhere else to live. He tells me he can live with his grandmother. So he doesn't have to be in the same space. He does need a one-time police escort to get his things from that location, Your Honor. He tells me that the police officers intervened into an argument he was having with the alleged victim. She was not interested in pressing charges against him, but the police officer was insistent that that should happen. Your Honor, I acknowledge that my client does have some history, but right now he's not employed. So he's not in a position to pay any money towards a bond. I would ask the court to take that into consideration. Also, based on what I heard the prosecution state, it seems that he is in a situation where he has another charge where there is no bond on that. So any kind of surety bond that he gets, he won't be able to post because he's not employed. Nothing further, Your Honor.
All right, I'm sorry, and the 3843 Jonesboro Road was the address of the incident. What is the address for their shared residence? Does anyone know?
I do not have the listed address of where they share residence.
All right. What I'll say, Ms. McLeod, do you have it?
I do not, Your Honor.
All right, what I'll say then is that he can, I'm sorry, who's speaking? Okay. All right, at this time, the defendant is going to receive a $2,500 surety bond. He's to have no contact with the alleged victim, last name Williams. He can return one time to the shared residence with a member of law enforcement, and he must also stay away from that address as well as the 3843 Jonesboro Road. He is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor, thank you.
Nothing further, Your Honor. But that
All
does
right.
conclude my business before the court today. May I be excused?
Yes, you may. Have a great afternoon, Ms. McLeod. Take care.
Thank you, Judge.
All right, who do we have next?
Next, we have position number 7, Mr. Jackson, Kamani Jackson.
Mr. Jackson, your case is 22 CR 007698C, in which you're charged with theft by shoplifting with the offense date of November the 8th. Do you understand your rights?
Yes.
All right, Mr. Howard.
Yeah, I missed it too. Judge, question, what was the bond for the last case?
2,500.
Good, okay. Kamani Jackson, second arrest. Last was 2018 robbery out of West Hollywood. It was dismissed.
All right, thank you. All right, Ms. Duncan.
Yes, Your Honor, this incident occurred yesterday at Saks Fifth Avenue in Phipps Plaza located at 3440 Peachtree Road Northeast. The defendant, officers responded to a shoplifting call. Upon arrival, they met with the reporting party, which was the asset protection manager, Mr. Chad Harris, who had advised officers that he had saw on camera the defendant, in this case, concealing a shirt on his person under his shirt and walking past all points of sale And that shirt value was over $300. In this case, we do have a little concern about the risk of reoffense. Given that, Your Honor, we believe if this defendant does have a Georgia residence, we are amenable to a 3,000 signature bond through pretrial services. If the defendant is not a Georgia resident, however, the state will be recommending a $500 surety bond and stay away from Phipps Plaza. No alcohol, drugs, weapons, no further violations of Georgia law, and a theft class. Nothing further from the state.
Thank you, Ms. Duncan. Ms. Moses Counts?
Yes, Your Honor. My client is 28 years old. He is a Georgia resident. He has a good address of 730 Glenwood Avenue, Southeast, apartment 27 in Atlanta. He does work at Saks Fifth and has been working there for over 30 days. Based on his income, he would not qualify for the services of the public defender's office, and he has been made aware of that after today. I would ask for your consideration based on his lack of any criminal convictions in really history that you would consider him for a signature bond.
All right, thank you. At this time, the defendant will receive a $3,000 signature bond through the jail. He is not to return to Phipps Plaza unless he is still employed. If he's not employed, he must avoid the mall and not return there by any means. He is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state.
All
And
right.
you said
best
that
of-
was through the jail, Your Honor?
I did.
Okay.
All right, best of luck to you, sir. Who do we have next?
We got position number 8, Mr. Rhett Kearsley.
All right, Mr. Kearsley, your case number is 22 CR 007699E, in which you're charged with battery with the offense date of October the 16th of 2022. You understand your rights?
I do.
All right, thank you. Mr. Howard, please proceed.
Second arrest. I got 2004 misdemeanor possession of marijuana. Yeah, that's all I have. State, you got anything else?
I'm sure Ms. Duncan will make us aware. Ms. Duncan, please proceed.
Okay, Your Honor, this incident occurred on October 16, 2022 at 2211 Collins Drive, which is the Atlanta River Walk Trail. The victim in this case is Seth Adabdi, and that's ABDI. Officers responded to the victim in this case, who had called officers and stated that a man that he knows from his neighborhood who had been threatening him recently had hit him, struck him in the face while they were riding past each other on a bicycle nature trail. The officers notated a visible injury to the victim's eye, and they stated that it was very visible, red, and swelling as they were speaking to the victim in this case. We have some concern about the risk of offense here, given the information that indicated that they are neighbors, and this seems to be some type of continuing escalation of prior difficulties that they've had. The state does not have any additional criminal history for this victim, but given the seriousness of the nature of the offense, the violence, and the injuries alleged, the state believes that a $3,000 surety is more than reasonable. No further contact with the victim in this case, name as stated on record, one-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further.
All right, I'm gonna sound for the alleged victim in this case, last name Abdi at this time. Is Mr. Abdi present? All right, hearing none, please proceed, Ms. Moses Counts.
Thank you, Your Honor. My client is 44 years old. He does have a good address of 2069 Callaway Court in Atlanta. He does have a 13-year-old child that he is a sole provider for, that he does need to get back to. He does have good employment. He works at Intuit as a producer. He would not qualify based on his income for the services of the public defender after today, and has been informed of that. He has great ties to the state. He's been here since 1998. Therefore, I don't believe that he would be a flight risk, Your Honor. Based on the lack of any criminal history in any recent time, I would ask for your consideration of a signature bond. Obviously, Your Honor, these are just mere allegations that the state has gave a recitation of. And so based on that, based on the lack of history and the fact that he has no other prior violent criminal convictions, I would ask for a signature bond.
All right, thank you. At this time, the defendant will receive a $4,000 signature bond through pretrial services. He's to take the one-day anger awareness course, have absolutely no contact with the alleged victim, last name Abdi, and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state.
All right, best of luck to you, sir.
Judge,
we
you
have-
said that he had to take what class? I'm sorry.
The one-day anger awareness.
Thank you.
All right.
Next, we have position number 9, Mr. Kevin Porter.
All right, Mr. Porter, your case number is 22CR007697G, in which you're charged with 1 count of battery, family violence, and 1 count of cruelty to children in the 3rd degree with the offense date of November the 7th. Do you understand your rights here today?
Yes.
All right, Mr. Howard.
Your Honor, if I may, before we get into the details in this case, the state has submitted through Ms. Bridgewater an order for a transfer of this case to the DA's office. DB unit head Simone Hilton has accepted the transfer of this case. Normally, the protocol that we have in place starting in the last 2 or 3 months is when the transfer order is signed, we ask for a one-day reset so the case can be placed on the first appearance calendar and addressed before the court, where the DA's office has indicated they have accepted the case.
All right, understood. And you said that it has been accepted and there's proof of acceptance, Ms. Falk?
Yes, Your Honor, I can email that to Ms. Bridgewater right now if you like.
All right, so this case.
And I do have the transfer order for you to sign, Judge.
All right, wonderful. All right, Mr. Porter, your case will be reset till tomorrow. This charge is no longer before me here in state court. It has been elevated to Superior Court, and a Superior Court judge or someone sitting in Superior Court will hear and assign a bond for you tomorrow. All right? Yes, you can ask me a very brief question, but don't infringe on your right to remain silent. Go ahead.
Dominique's on the line if she can speak.
She'll need to log on again tomorrow when the case will actually be heard. It will not be heard by me today. All right?
Thank you.
All right. Best of luck to you. Miss, I'm sorry, what was the name of the victim in this case, Ms. Falk?
Your Honor, the name of the victim in this case is Dominique Foy, F-O-Y.
Ms. Foy, this case is going to be reset to tomorrow. So if you'd like to make a statement or watch that proceeding tomorrow, you'll need to log on then, okay?
Okay, will do. Thank you.
All right, thank you. All right, best of luck to you both. All right, who do we have next?
We have position number 10, Mr. Joseph Presley. Come on.
All right, good afternoon, Mr. Presley. Your case number is 22CR007700A, in which you're charged with 1 count of battery with the offense date of November the 8th. Do you understand your rights?
Yes.
All right, Mr. Howard.
This 10th arrest. Last arrest was earlier this year, probation violation. Possession of a Schedule 2 out of Gwinnett. He's on probation, possession of cocaine. As of April of this year, they gave him 1 year. Theft by taking, they gave him 5 years probation for that. 2021 trespass probation. 2020 probation, play a NOLO to obstruction. 2020 giving false name conviction. Let's see.
Okay.
28.
I think I've got it. All right. Thank you, Mr. Howard. I appreciate that. Ms. Duncan, please proceed.
This incident occurred yesterday at 111 Boulevard Northeast in Atlanta, which is a Chevron. In this instance, officers were flagged down in the area by someone working inside of that Chevron, and they indicated it was a manager who ran out and advised that the defendant had run across the street after attacking one of the employees inside of the store. That victim is Haldahar Sikadar, and that's H-A-L-A-D-H-A-R, last name S-I-K-D-A-D-H-A-R. Indicated to officers that at that time, the defendant had come into the store and was to buy a single black and mild, and upon leaving the store, he attempted to shoplift a beverage from the store, and the victim attempted to stop him, and that's when the victim was struck by the defendant in this case, leaving a laceration on his left eye. and then ran across the street. He was later pointed out because he was still visible by others in the property. Officers detained the defendant, brought him back to that location, and he was later identified by the victim in this case. We do have some concern or serious concern about this defendant's likelihood to respond positively to the legal process. As pre-trial stated, this defendant has several probation violations, 2018, 2020, and 2022. In addition, this defendant is currently on probation, so that is likely that this defendant is now also again violating probation. Given the serious nature of the offenses alleged and this defendant's criminal history with several probation violations and active probation, we believe a $3,000 surety is more than reasonable in this case. No further contact with the victims whose name has previously been stated on the record, and stay away from that chevron at the address previously stated on the record. One-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, thank you. Is the victim last name Sidhar or Sidkar perhaps on the Zoom conference and wishes to be heard? I don't believe so, so we'll go to you, Ms. Kim. Ms. Kim, please proceed.
I'm sorry, not to interrupt, Your Honor. We were able to speak with the victim. They did state that they may be on the Zoom. However, as you see, they are not. However, he stated that he had never met this defendant before, and he wanted him to stop stealing from the store, and that he does not want him to be able to return to that store, and would like to continue with pressing of charges against this defendant. Nothing further.
Understood. All right, thank you, Ms. Kim, please proceed.
Yes, Your Honor. Mr. Joseph Presley is 23 years old, and he has been here in Georgia for 23 years. He's a single. He does not have parents or family members who can bond him out. I tried to reach his mother, however, I could not reach his mother at all. He has not had any employment for the last whole year, and he graduated from high school. Due to the fact that he has been unemployed, he has no financial means, and he does not have anybody to support and pay for the bond. So even $1,000 will be no bond for him at this point. We would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, we ask that $1,000 good bond that is already set on this case to be continued and sustained. Thank you.
All right, at this time, the defendant will receive a $2,000 surety bond. He's to stay away from the address on Boulevard, have no contact with the alleged victim in this case, and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. Thank you.
All right, best of luck to you, Mr. Presley. Who do we have next?
13 Simpkins.
All right, good afternoon, Mr. Simpkins. Your case number is 22 CR 7689J, in which you're charged with simple battery family violence with the offense date of November the 8th. You understand your rights?
Yes.
All right, Ms. Gillette.
Yes, Your Honor. On November 8th, 2022, Officer Dismangles with the Atlanta Police Department was dispatched to 390 17th Street, apartment 2059. Officers received a call from a neighbor that wished to remain anonymous. And the officers checked with the residents of the unit of 2059, and they advised that everything was fine. This was the defendant and the victim at that time. Then did have to make another call to police that same night, advised he heard arguing, items moving, and the female victim in this case, Miss Bria Barkley, was telling the defendant to get out several times. Officers went back out to the location, and they were leaving unit 2059. They saw the defendant walking on the sidewalk, and they spoke with him and got his version of the events. They then spoke with the victim, Miss Bria Barkley, and that's BRIABARKLEY. Officers noticed that it looked like she had been crying and that her eyes were puffy. She stated that she and the defendant have been living together since August. She stated the first time the police arrived, the two of them had just been arguing verbally. And then later on, after the officers left, they began arguing again. The victim began moving items around the home, and at that time, the defendant pushed a desk towards the victim, which hit her in the back, and her back was in pain at that time. The 7-year-old child of the victim was also present as well, and witnessed this incident. And when the defendant struck the victim with the desk, a piece of the desk broke off, and it did hit the 7-year-old daughter as well. There was a faint mark on the daughter's finger, but there was no real bruising or anything like that. After this, the victim did tell the defendant to leave at that time several times, and he would not leave the apartment because he said that his name was on the lease. Officers did arrest him at this time, but he does have an open felony aggravated assault, strangulation, and battery family violence against the same victim. Case number 22 SC 180715. That arrest was from 2021. He's out on a $35,000 surety bond, and is to not have any in-person contact with Ms. Barkley. So he has not been following the order of the court. Due to that, the state is requesting a $10,000 cash bond, no contact with the victims, no alcohol, drugs, or weapons. Due to the family violence nature of this charge and his open family violence case, which is a felony case, the state argues that he poses a risk of reoffending once again while out on bond. We have made contact with the victim. She is afraid of the defendant. She does not want him to get out, and she does not want contact with the defendant. So that's the state's recommendation at this time, Your Honor.
All right, thank you. I'm sorry, can you please give me the victim's last name? I am gonna sound from her, even though I do not believe I see members of the public still on the screen.
Yes, Your Honor. It's Barkley, Barkley.
Okay, Ms. Barkley, if you are present on the Zoom conference and wish to be heard, this is your opportunity to speak. All right, hearing none, Ms. Kim?
Yes, Your Honor. Mr. Simpkins is 29 years old, and he has, well, they are co-parents basically, even though they used to live together, because that place, that apartment is in Mr. Simpkins' name. However, he plans to move out, and they have one child together. And he has been here in Georgia ever since 2012, last 10 years. And other than one child and his uncle, he does not have anybody else here. He has not had any job for last 11 months. Because of unemployment for almost a year, he has very limited financial resources. And he has a bachelor's degree from Morehouse College for business marketing. We would like to request him to give him definitely surety bond, maximum $3,000 to $3,000 surety bond. I think $10,000 cash will be like no bond to him. That is way too much. That's
Right.
he has no objection to stay away or no further contact. Thank you.
And
All right.
Your Honor, I'm sorry, for the record, I don't think I included the stay away, but we would be asking to stay away from the 390 17th Street apartment 2059.
All right. All right, at this time, the defendant will receive a $20,000 surety bond. He's to have no contact whatsoever with the alleged victim in this case. He is to stay away from the address on 17th Street. He can return one time with a member of law enforcement to get any items. And he is to have no weapons, drugs, or alcohol as a condition. Is there anything further?
Your Honor, since the apartment is in his name, if Mrs. Barkley decides to move out, can he return to his
Yes,
home?
he can return with law enforcement to ascertain whether or not the victim is there. If the victim is not there, he can return to that location. Should the victim choose to remain or be still present in that address, he must stay away from that location. I see you have a question, Mr. Simpkins. I don't want you to interfere with your right to remain silent. The best thing for you to do is to call Ms. Kim. If you have a limited question about the bond, you can ask that at this point.
I'm sorry, I don't have a limited, I was just wondering if there was a statement from what I stated occurred and.
Okay, please speak to Ms. Kim. We're not here to discuss the facts of your case at this time, all right? Ms. Kim,
Okay.
will you please give him a call shortly hereafter?
Sure,
Thank
absolutely.
you. Thank you. All right, I believe that will conclude Mr. Simpkins' case. Best of luck to you.
16 Willis.
All right, good afternoon, Mr. Willis. Your case is 22 CR 007692A, in which you're charged with theft by shoplifting with the offense date of November the 7th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
13 total. Last arrest was 2010, possession of cocaine.
Whoa.
Did I get that wrong? Oh, no. Yeah, possession of cocaine. It was dismissed. Before that was a 2004 battery, family violence, second and subsequent offense, hindering person from making an emergency call. That was dead, doctor. Before that was 03 simple battery conviction. And before that was in the 90s.
Okay, that's good. Thank you. Ms. Salette?
Your Honor, on November 7th, 2022, Officer Workman was dispatched to 3332 Colville Avenue, that's Colville, Hateville, which is a corner market store, in regards to a theft. Upon arrival, Officer Workman met with the complainant, Mr. Daredia, Daredia, and he showed officer the defendant on surveillance camera walking to the refrigerator at the store, opening up the refrigerator and taking a sandwich. The defendant then concealed the sandwich in his left front black pants pocket and left the place of business, that corner market. The defendant admitted on body camera that he did take the sandwich without paying for it because he had been cheated by the victim many times in the past. Relevant arrest in reference to theft by shoplifting for this defendant. 1983 has a burglary arrest, 1985 theft by taking, and I did see a criminal trespass from 1993. In light of his history being so long ago, the state is recommending a $3,000 signature bond through pretrial services and a stay away from the incident location, no alcohol, drugs, or weapons while out on bond.
Ms. Kim, your response?
No objection, Your Honor.
All right, at this time, the defendant will receive a $5,000 signature bond through the jail. He is to absolutely stay away from that corner market in Hateville, and he is to have no alcohol, drugs, or weapons. Is there anything further? Anything further? Okay, best of luck to you, sir. That concludes this case.
500 or
I'll
5,000.
explain it to you, Mr. Willis. You're good.
Number 2 bonded out.
All right, so that concludes the entire calendar.
Yes, we're completed here.
All right, have a great afternoon. Take care, you all. Ms. Bridgewater, will you please review this calendar for me?
Absolutely. Once again, the reset date for the SAP calendar is November the 22nd. Okay, position number 1 is reset to that SAP calendar with a $1,000 good bond. Position 2 is reset further notice as the defendant bonded out. Position 3 reset further notice with a $2,500 SOB through the jail. Position 4 is reset further notice with a $6,000 total SOB through pretrial. Position 5 is reset to the SAP calendar, $5,000 good bond. Okay. Position 6 is going to the SAP calendar with a $2,500 good bond. Position 7 reset further notice with a $3,000 SOB through the jail. Position 8. I'm trying to write that down. Hold on, I'm gonna come back to that one.
Yeah, I didn't get that one either.
Position number 8 is a $4,000 SOB through pretrial. Position 9 is being transferred to Superior Court. Position 10 is going to the SAP calendar with a $2,000 good bond. Position 11, reset further notice with a $6,000 SOB through pretrial. Position 12 is going to the SAP calendar with a $3,500 good bond. Position 13, SAP calendar with a $20,000 good bond. Position 14, SAP calendar, $1,500 good bond. Position 15, SAP calendar with a $500 good bond. And position number 16, reset further notice with a $5,000 SOB through the jail. Are there any questions, comments, corrections, or otherwise? If not, there you have
All
it.
right, hearing none, we'll be in recess until tomorrow's SCA calendar on November the 10th. Everyone take care. Have a great rest of your afternoon. Bye-bye.
Goodbye, everybody.
Bye.
Yes. I'm telling you. Awesome, awesome, awesome.